What's his name? Jim what?
Oh, no, that's Jim.
We are on section 14, which deals with constructive trusts, resulting trusts, declaratory judgments. It also deals with ecclesiastical courts. So we have a number of different things we've got to talk about today. And the first case that we start with is Sanguinetti versus Nantucket Construction. And let's take a look at the case. You've looked at it before, but I've got some questions on it. And there's some questions again about equitable defenses such as laches and perhaps estoppel, so we have to look at that again. But the successor trustee, Lucille Sanguinetti, seeks a judgment, declaratory judgment, which we've looked at before, declaring the trust to be the owner of realty, and saying that the estate of Roy Sanguinetti is not subject to any claim of the defendant. Now, he was a lawyer in town for many years, and no suit was brought till after he died. And I think, in part, he's a pretty easy target at this point, certainly at least in part because he can't defend himself. But let me ask you about that. I mean, he did a lot of things wrong, right? Do we agree on that? Is that he appears to be doing business with his client. He's got access to the registry at times when he likely shouldn't. And so it's hard to defend, if at all, what he did here, because he exposed himself to this type of problem. But I want to think about whether he still should be, whether this suit should have been brought earlier, whether the plaintiffs were on notice or the defendants were on notice that something was amiss and did nothing. I mean, at some point, don't they have to be vigilant in order to protect their rights? But in order to reverse what the trial court find between the statements, findings of fact, and conclusions of law, they must be clearly erroneous. So let me ask you that. What did Sanguinetti do wrong here that at this point now we should be saying, well, listen, why would we want to help him out at all? I mean, has he just done too many things that are suspicious? Because I'm thinking that at some point the defendants knew that he was claiming ownership to that property, and they did nothing about it even after getting that warning. I thought if you sleep on your rights, you potentially lose your rights. And tell me about, is this a constructive trust or a resulting trust that the court is looking at the end of the day?
Definitely a constructive trust.
Okay, why is it definitely a constructive trust?
Because of the unjust enrichment.
So the argument is he's been unjustly enriched
At the detriment of others, because he had a fiduciary relationship and a duty, and he violated that.
Okay, so it's
He got legal title to property by violating his fiduciary relationship with his client.
so you got to be in a fiduciary relationship.
Or fraud, or obtain confidential information at your advantage to the detriment of who gave it to you.
Okay, and that's about right? It says a constructive trust is imposed in order to avoid the unjust enrichment, as Jim said, of one party at the expense of another, where legal title is obtained A, by fraud, B, in violation of a fiduciary relationship, or C, where the information confidentially given or acquired is used to the advantage of the recipient at the expense of the one who disclosed the information. An attorney is in a fiduciary relationship with his client, right?
Yes.
Aren't you?
Yes.
Okay, so you are in a fiduciary relationship with your client, and then the concern has to be whether that information confidentially given or acquired is going to be used to the advantage of, in this case, the attorney, at the expense of the one who disclosed the information. And somehow he does acquire, or the trust acquires, the interest in this property, even though this at one point was his client's property. Are there any circumstances under which you would, in essence, do business with your client? Because that's how this all starts out, doesn't it? The client needs a loan. He goes to the lawyer in town who supposedly can get everything done. The lawyer helps him, but then at some point, the lawyer, as the court says here, who was in a position of trust, not only acted as the treasurer and director of and the attorney for NCC, but also as Roundsville's personal attorney. In such positions, it was incumbent on Sanguinetti to show that he fully and faithfully discharged all his duties to his client, not only by refraining from any misrepresentation or concealment of any material fact, but by active diligence to see that the client was fully informed of the nature and effect of the transaction proposed and of his own rights and interests in the subject matter involved. The attorney must see to it that his client is so placed as to be able to deal with him at arm's length without being swayed by the relation of trust and confidence which exists between them. So how is it, can you do business with your client? Is it a good idea? Obviously, when you look at this case, you wouldn't come away thinking that it's a good idea to do business with your client, but to what extent can you? Because it seems to me that in part, at least one could argue, that in trying to assist his clients, he put himself in really an indefensible position, certainly post his death when he no longer can explain what he was thinking about as to how all of these transactions came about. I mean, he looks like he was taking advantage of the situation. Maybe there was an explanation, but are there circumstances under which you could do this?
I thought the model rules prohibited you doing business with your client.
So you can't do business with your client?
You can, as long as you relieve yourselves of the legal duties.
What's that mean?
But you could own a McDonald's with your client as long as you don't have any.
But then I can't do the legal business anymore.
Not for that, because you'd have a conflict of interest.
Okay, because I can't.
You want to represent him in that contract.
While I'm at odds with you. Excuse me, potentially, right? So there is no business deal in which you could be partners with your client. Client comes to you and says, I want to start a new business with some high-tech company. I have no money to pay you, but I'd give you stock. Can we do that? Because, I mean, 1,000 shares or 5% of the stock might be worth a lot more money down the road than a lousy $500 or $1,000. Can I take that as compensation? Because I could see where someone later on would say, when that little internet company turns out to be Yahoo 2, geez, you really took advantage of this situation. Can I take something other than cash? I mean, because in essence, then I am in business with them, aren't I? Or not?
It's a little bit different. That's
What's
payment for services rendered. It's not like starting a business with the other person.
So we can still go forward, though? I can continue to represent the company, even though now I have a 5% interest in that company?
Maybe not give legal advice. It's just in your best interest. But
So wait a minute. So now the fact that I've taken compensation, I'm now out as the lawyer going forward, but I could take it at the outset, the money in stock?
I think you have to settle one.
You have to what?
I think you have to cut off one. You can't do both.
Okay, but could I take payment in the form of stock, do you think?
I think so.
In the
For the-
company that you're representing?
Yes.
I don't think so.
No, I don't think so.
So it's cash or nothing?
And even then, you have to be careful where that cash comes from, too. Yeah.
What do you mean I got to be careful where the cash comes from?
It has to come from the, if you're working for a firm, it's got to come from the firm's, like, gross thing. It can't come from, like like a director of the firm or something like that. The rules are very strict on that, yeah.
So the problem is, it's not just then going to be sanguinetti. It's going to be when you have a client who needs perhaps more than legal advice. They need financial assistance. Maybe you have to help place the loan for them. Or maybe you're like this guy. You're the person in town we go to when we want to get something done. And every town has a person like that, right? Every town has a person that if you want something done at the zoning board, this is the lawyer you hire. You want something done at the planning board, this is the firm. They're going to be able to help maneuver the process and get it done because they're from that town. And there's a different, you have a different relationship. So if you're that person, you're exposing your back like this because you're potentially involved to a greater extent than just sort of cash compensation. I'll put the deal together, but I want 10% of the deal. Can I not ask for that?
I don't think you can, no.
I think
Is it adverse to the client?
Well, I don't know. I'm asking you. Do you think it's adverse? I'm going to take a piece of the deal by the time we're done. But the only way this deal gets done is with me involved. And that may be what happened down here in Martha's Vineyard. I can't think of probably a more closed community, right?
Is 10% of the business the only means the client has to pay?
Probably, well, I don't know. Does that matter to you?
I think it does.
Because maybe I'd rather have the 10% of the deal than the cash anyway.
I think I would too.
So how come your contingent fees don't do this same problem? Because contingent fees, we could pay you otherwise, but generally that third is going to probably be a lot better than your hourly rate, and you lawyers don't have a problem with that. But now I want to make you part of the business deal, or you want part of the business deal, and that's a no-no. Why?
Maybe there's an issue concerning if someone's working for a company and getting paid contingent upon how that company performs, then maybe there would be kind of a discrepancy between the quality of
Might be better?
service that, well, yeah, it would be better, but I
Bless
mean,
you.
maybe that's against, like, as far as public policy is concerned, like, oh, if you're kind of like dual operating in a company, then you're going to be, like, it's a conflict of interest in a way.
Well, there are probably conflicts with it. I wonder, looking at this case, whether you're potentially wearing too many hats exposes you, even, and I'm going to say this, and I don't necessarily agree with this, that unfairly, like sanguinetti. I'm not sure this is unfair. I think he should have seen some of this coming. He should have seen some of this coming. He just way too many hats on, way too much involvement. But I also think the plaintiff should have seen something. At one point, they saw him on the bog.
He sent an eviction notice too.
And he sent an eviction notice, and the alleged owners say, well, we just thought that was him. Whoa, whoa, whoa. Someone says, hey, I own this land, not you, and you can sit back and do nothing? Because to me, it's kind of easy once he's dead to say, okay, here's what really was going on. He didn't own it, we did. Because that does sound like laches, or it does sound like statute of limitations. It does sound like, to some extent, and there's an equitable axiom that says equity aids the vigilant. These people were far from vigilant about protecting their rights. At some point, he was claiming ownership. They had a disagreement, and these folks did nothing. Now, I want to get back to the constructive trust, because we have constructive trust, we have resulting trust, and they are equitable remedies that try to remedy, in essence, the same wrong. Someone owning property of some sort, usually it's real estate, but it doesn't have to be, and they shouldn't continue to hold the beneficial ownership of that real estate, and depends on the circumstances as to how it was acquired and what the situation is as to whether it would be resulting trust or a constructive trust. Here, the court did in fact impose a constructive trust upon the real estate, feeling that there was a fiduciary relationship that was violated, there was information that was confidentially given and then used against the client that had provided that to Sanguinetti. Therefore, they have no problem imposing a constructive trust on the land for the benefit of his client. And this decision goes even further and says there should have been an order to Lucille Sanguinetti, a successor trustee, to transfer the property to the true owner, who is in the who was the client. Sanguinetti was the treasurer, director, and attorney for NCC. Here's the problem, and it's not just your code of ethics. You got to worry about down the road how someone is going to say how you took advantage of the situation, right? We are in a position of trust. We are in a superior power position to our client. They may not be, some may be, and this is maybe potentially more dangerous, they may not be as schooled in the law as you. And therefore, you've got to be careful that you don't take advantage of that position of both trust and power. The problem is sometimes is that they're seeking services over and above what you'd normally do as a lawyer. And the fact is that you may want to provide those services. You may want the compensation. The problem is, how is it going to look down the road, especially if we can look at the code of ethics and say, well, you shouldn't have done this. And we look at this. Even if he was trying to help as best he could, he's got too many hats on to defend the position at a later point. Think about then, it talks about a couple of things that I do worry about here, and I think should have been advanced to a greater extent, but the court relatively easily disposes of it. They say the claim isn't barred by the statute of limitations. Brownsville didn't have actual knowledge that the beneficiaries of the trust might be persons other than NCC until 1970. And then what they use here is an argument that helps to overcome a statute of limitations defense, and it's called fraudulent concealment. When a wrongdoer fraudulently conceals their activities from the person wronged, fraudulent concealment is a defense that can be used to overcome a statute of limitations argument. Because under those circumstances where the person has fraudulently concealed their activities from you, that period in which there's been fraudulent concealment has to come out of the statute of limitations period. Because you didn't have notice and there was some intent to conceal what it is in fact they were doing. So fraudulent concealment is an argument that can defeat the statute of limitations defense. Statute of limitations, as you know, is the time period in which an action should be brought. I am more sympathetic to the laches defense here, even though the court says, and this is at 238, the defense of laches is not a bar to recovery in this case. Even assuming that the defendants were aware of Sanguinetti's adverse interests as early as December of 1968. There appears to have been no acquiescence by the defendants in wrongful acts of Sanguinetti, no lack of diligence on their part in seeking a remedy, no showing that there was any prejudice. He dies. How is that not an argument for laches? Laches being a delay in asserting your rights that causes prejudice to the other side. There certainly has been some delay. If you look at when they were, what I think, put on notice that they should be doing something. And the prejudice would be, who would know more and be able to testify to a greater extent than Sanguinetti? And when the suit is brought after his death, that would seem to be a much better argument that it might be untimely. The problem is, I think, is there's almost no way to develop cover or sympathy for Sanguinetti because as a lawyer, he simply should have known better than to have his finger in virtually everything that was part of this deal. The problem is the courts are not going to be sympathetic to him or you if you're not sufficiently careful as to not just improprieties, but the appearance of an impropriety. And that's what I think ruins him, because I do think in a different situation, if the person wasn't a lawyer, you might have the court give a little more credence to a laches defense here. Because I think they were put on notice. I think they should have started to do something at that point, at the minimum, to investigate. Having done nothing till after his death is very worrisome to me. I can understand how the court dismisses it because they want lawyers who can be trusted, and he's just done too many things that create the appearance of an impropriety if it's not improper, and it may well be at any rate. Also,
Did he really conceal anything, though?
Did-
So how did they get past the statute of limitations?
did he really conceal any? Did he?
Yeah.
That's what the question.
He was sending eviction notices, and it didn't seem like he was really going behind. They knew he was taking, they asked him for the money, so they knew he was buying out in this trust.
I don't disagree with you that, and this is what worries me about what to me strengthens the Lachey's defense as well. I think they had enough notice that they should have done something. If this was just another business partner or someone else they had been involved with, I think you would have a much stronger argument that statute of limitations and Lachey's should be given greater weight. I think the concern here is they felt, as a lawyer, as someone in a fiduciary relationship, he had to even put them more on notice than he did. As Jim points out, an eviction notice doesn't give you some concern. Telling you, get off my land, this is mine, doesn't give you some concern as to what's taken place. Again, I think, I don't know whether, and this is what I think is unfortunate from Sanguinetti's point. I'm not sure he concealed anything. And I think if he was alive to testify, I think we would have had significantly different evidence coming from that side. He's not. That's why the argument for Lachey's is, to me, stronger than the court gives it credence. But I think they're punishing the lawyer for what are some improprieties. I don't know whether the client was unaware to the extent he had tried to help them, but that help crossed the line at some point without clear paperwork that would evidence that the client was aware of it. And that's probably the problem more than anything else, is that if you're going to do stuff like this, then you're going to have them sign off. You're probably going to have to send them to another lawyer, as you guys are saying. At some point, you can't be the lawyer, you can't be the financer, you can't be the business partner, and you can't be the superior business partner, as it turns out, and take over the business, because there's just too much concern that you've taken advantage of that fiduciary relationship. I don't disagree with you on it. I think the alternative, though, would be to reward potentially the lawyer who, at the minimum, has done some improper actions, even if they were not malevolent, even if they were designed to help the client. They are improper without us being able to clearly prove that the client was well aware of it, understood it, and not just acquiesced, but wanted that level of assistance. With him dead, we'll never know. So I think, to me, it's a good case on a constructive trust. I think it's correct at the end of the day, but it's also an important case for you to look at and say, you've got to be careful, even if this stuff was proper. Obviously, this isn't. You can't be too involved with your client's affairs, or you're going to be sued and you're going to likely lose. Take a look at Sullivan versus Rooney, which is an interesting case. Two unmarried people. The house that the male owned, and when they broke up, she sued, and they were living here in Reading, and he attended law school at night. He paid the mortgage, obligations, taxes, utilities, insurance on the house. That was all in his name. The house was solely in his name, which she knew because he had told her that on the way to passing the papers. He said it was because of the veterans financing. The deed was recorded in his name alone, even though they lived together. She was a waitress. She put all her earnings and savings into the house, as it says here, paying for food and household supplies and for much of the furniture. She then sues in '84, bringing suit to obtain title to the house as a tenant in common. And then the question is, her name's not on the real estate. She can't show that she paid mortgage, taxes, or insurance, but she would like to be a tenant in common in that property. And part of the issue would be, Massachusetts, like many states, we don't recognize palimony. So the fact is that if you are unmarried and separate, there's really no community property. But she would like the house, or at least half the house, to be in her name. And what she's arguing is that he promised to convey title, joint title to her. She says he reiterated that promise on several occasions. The judge finds that he admitted those things. I don't know to what extent that is or isn't true. And the judge found that in reliance on those promises, she was induced to stay. She did, in fact, stay. The judge decides that the defendant would be unjustly enriched if he were allowed to keep sole title to the house, orders the defendant to convey a half interest in the house, and the case is now at the Supreme Court. If it's a compensation for services, it's a quantum merit argument, meaning she can recover the fair value of her services. But the biggest thing that we've got here, again, I remember from first year property, I assume you do, the statute of fraud says that if it's an agreement concerning an interest in land, it's got to be in writing, right? There is no agreement concerning an interest in land, in writing, certainly. So why the hell isn't she out?
I think the court wanted to do the right thing.
But what's that mean, do the right thing? I mean, we've got a pretty clear...
I think she was a sympathetic figure, and the court wanted to find a way to find in her favor.
Because if it's not this, she gets nothing.
Right.
But the law says she gets nothing, isn't it? Go ahead.
I agree with him. I think it's because she would have, it would have been in writing, except for the fact that he pretty much convinced her not to put it in writing so that they can get whatever the discount was, or the veterans.
Well, they could have put it in writing afterwards. They could have put it in writing at any time. Now, you don't buy this story of hers, do you? He was going to give me half. Well, he didn't. He never did.
Court bought it.
Okay, but aren't you a little worried about it? So we have a disagreement. We split up, and now I'm telling you the deal is different than what all the documentation says. So let's give her half the house on a constructive trust or resulting trust theory. I mean, this after-the-fact, self-interested testimony has to be a little suspect. No? She can't show any money went to pay mortgage, taxes, or insurance. So we're just going to completely throw out the statute of frauds because, we've got a sympathetic plaintiff. She was a waitress, and he's now a lawyer. So let's take half his house and give it to her. So could your boyfriend, girlfriend get half your law degree? Or the value of it going forward?
There was a case where there were two students,
Yep.
and that one had agreed to put the other through medical school, and then they were going to switch, and I think they split up, and the court wound up finding in favor of the one who was left behind without the opportunity to go.
So now it's time for you to pay for med school.
Yeah.
Okay, but so in that, on a quantum merit argument, the reasonable value of the services? Because is that...
I'm trying to remember whether that was what they based it on, but they found in favor of the person who had been left.
Well, in order to have the constructive trust, Jim was just telling us, right? It says here that the defendant holds one half the property on a constructive trust in favor of the plaintiff. We accept the plaintiff's argument. The evidence in the judge's finding demonstrate that the judgment should be upheld on the theory of a constructive trust. The judge's unchallenged findings of fact demonstrated that there was a fiduciary relationship between the parties and that the defendant violated his fiduciary duty to the plaintiff. So you're in a fiduciary relationship with your boyfriend, girlfriend now?
Why wouldn't the legislature just make common law marriage if that's what they wanted to do?
Well, that is an argument that in this case the court is sort of skirting the common law marriage rule in Massachusetts. So are you in a fiduciary relationship with your boyfriend, girlfriend?
No.
You're not. No, you're not, because that's part of the finding here, right?
You personally, Steve, or?
We're not required to act for anyone.
You're not required, not for anyone? For anyone?
Yeah, personally. When we're talking about girlfriends and boyfriends, I mean, that's pretty personal, I don't know.
Well, but, so are you or not required to act in a fiduciary capacity for your boyfriend, girlfriend? Does it make a difference if that boyfriend, girlfriend lives with you like this one did?
I'm not required to
Yeah, if you
act.
tell them to quit their job and you're gonna take care of them like this dope did, yeah.
No.
Yeah, but do you buy that he did that?
Yeah.
Quit your job? Why do we so willingly accept that he said, oh yeah, quit your job, come to live with me in Reading?
They must have had evidence.
Huh?
They must have
Yeah,
had
I mean, the
evidence.
court.
Well, what's the evidence? So what's the evidence? That this is what she did?
I mean,
Maybe
there's
he
no evidence.
admitted it in court.
Well, it's the judge says that he admitted it. I have trouble believing that he admitted to making some promise, the promises.
Yeah, but even if he did, it's still, they should.
Still not
just
right.
Legislature say that this common law marriage. I mean, you know, if common law marriage is common law marriage. The people wanted it, the legislature wrote it in the law. You know, it isn't. So, I mean, that's what essentially you're doing here.
So, well, wait a minute though, so is the court wrong when that says they were in a fiduciary relationship, or no, or are you saying, no, I'm not in a fiduciary relationship with this boyfriend, girlfriend, maybe a different one I might be?
Yeah, how long does it take to create a fiduciary?
Well, that's what I'm wondering, where we go here.
I think it's the second one, as you said.
Oh, that there will be some,
I think
but,
that you may get yourself, if you do certain things, you may get yourself in a position where you are required to act, which is what a fiduciary, part of a fiduciary duty is.
well, what are those things?
I just had it open, let me pull it up.
No, go ahead.
It seems like the court puts a lot of reliance on him because he supposedly is more experienced and more educated. So it's basically giving her a way out because she's.
So all of you are targets, because you're more
Yeah.
experienced and educated, and you're gonna be lawyers. No, is that right? So you especially, law students, are in a fiduciary relationship with your partners. Or not even partners, your occasional partners.
So only date the rich ones apparently.
Huh?
Only date the rich ones.
You're shaking your head, no, you don't accept this at all.
No.
But that's in order for the court to impose the constructive trust, they have to find the fiduciary relationship, don't they? Or fraud. And I don't know whether you're going to find fraud here either. Fraud has to be proven generally by clear and convincing evidence. So, go ahead.
No matter what, there's always going to be one spouse or boyfriend or girlfriend that most likely make more contributions to the house. So I feel like it's her own fault. She moved in with him. The house wasn't hers. She shouldn't get anything. Even if he promised, he can promise you the moon, the sky, whatever.
We lie. No, right?
That is true. Yeah.
They lie, don't they?
Yeah, all that.
And you can't believe those promises.
Well, apparently you can.
Well, based on Sullivan versus Rudy. Well, it is a case that when you look at it, it's at odds with both the statute of frauds and the argument about palimony and common law marriage. I mean, it does sort of twist what we would expect would be pretty firmly settled principles in law on their head in order to achieve. And I'm not so sure that you're not right when you say, well, the court wants to do what's right, what's fair here. But how do we, I guess I still worry, how do we know that? I mean, okay, you put all your money into paying for food, which you would have had to eat anyway, household supplies, and for much of the furniture. Well, you can keep your furniture. You would have had to pay rent. I mean, He's got evidence to show he paid all the mortgage obligations, taxes, utilities, insurance. She didn't contribute to any of those things by the facts of the case.
So we helped her out, and then she took him over with her, basically. I mean, and
No, they were living together, they were partners. She was contributing, but because there's nothing in writing saying she handed X amount of dollars weekly, she loses half that house? I don't think so.
Her name's not on the house, though. Her name's not on the house, her name's not on my car, her name's not on my savings
They weren't
account.
even living in
Would
the
you give her all, huh?
They weren't even living in the house. They were in Virginia at this point.
Oh, at this
They were
point?
renting the house out.
That's true.
Okay, right, but they had lived in the house.
I mean,
And
if
they
you
had
switch
lived
it,
together in Medford before that.
but if you
So
switch
so
it,
they have a history of living together, sharing expenses.
But that's different than being married, right? There's certain rights that, what are you saying? I
yeah, but if you
couldn't,
switch it around, let's say
Yeah.
I move in with a girl, okay, and she finds out a year later that he's a jerk, this wants nothing to do with him. A month later, she gets something in the mail, and he's like, hey, we live together, I quit my job at Market Basket, being a bagger, and, you know, I did dishes, and I walked the dog every night, and now I want half your house. Is that okay with you?
No, but they bought this house together with the idea of having a future together.
that's who?
Well, that's
That's
the
who?
case.
Okay, wait a minute. Wait a minute, I do actually want to explore Mark's point further. What if the genders were reversed? Would we be as sympathetic? Because I'll tell you, we did this case one time, and I had a student, was a police officer actually, and, came up when it was done. He said, that case, that's all. Is that real? I said, yeah. He said, I got to tell you, he got over a bad first marriage. Well, it wasn't complete. It was bad first marriage and stuff going on. Took his $50,000, gave it to the girlfriend. For various reasons, they put the house solely in her name. I don't know how many years later, they split up. He went to a lawyer and they said, well, you're not married, your name's not on the deed. You can't show that you paid any of the mortgage, taxes, insurance, and the like. He said, you're out. Now, would you give him half the house? You would.
Yeah, but they're both
No.
sharing, that home together.
What does that mean, sharing the home together? We're living together in her house, is the way. If I were her lawyer, you were living together in her house, basically free of charge for 3 or 4 years, and now you want half the house. No, right? That's the way you would paint it.
That's not how I would look at it, no.
What if your kids wanted to move out tomorrow, and they move out?
Thank God.
Then they leave, and they say, you know what, I lived here my whole life, I want half the house.
You know what I would say?
No,
I don't want it on.
but wait a minute though, isn't part of this the reason why we want these agreements with respect to the ownership of real estate in writing? Is they are valuable assets, and if something is going to affect that interest, we should have that firmly established. Geez, a contract for over $500 is supposed to be in writing. Now we're giving away half of people's houses. And are you serious that the genders don't matter here, or are you just saying that?
No, I am serious.
You'd be equally sympathetic to a 40-year-old man who said, I just didn't know enough. She was a business person. She said everything's going to be fine. I'm a law student. What do I know? Oh, what do you know? Don't you cover contracts first year?
You could
Law
make it even
students?
worse than that. What about a 40-year-old guy that dates younger women to get half their houses when he breaks up with them?
What goes on in that head? So all these young women have houses now.
Well, I'm just saying, you know what I mean? What if that's, I mean, you don't think that would have, if that's the cold, you don't think people would think of that?
Well, what about Mark's point and the point that you are encouraging then people to sue even though they might have very little support for the proposition?
Isn't there a history here that she can prove? We have been together, we have lived together. In this home, we've lived together in this home. We also moved to Virginia.
And year after year, I never put your name on the deed, and year after year, I never committed to you under the law, which would recognize your legal rights.
True story, Professor. I buy a house, well, my husband buys a house, the house we're living in. The attorney says to me, at the deed signing, he says, you know what, I'm throwing your name on it because we'd be here anyway down the line. Fast forward a few years, my husband's looking and he goes, how the hell did your name get on this? I don't remember that happening. I said, you gotta be quick, baby, or you lose.
Okay, but you were smart enough to have that name put on the deed.
That attorney thought of it, I never thought of it, I thought,
And you look so nice, Barbara Kelly, you know?
So, okay, but so,
But I didn't even think of that. The attorney thought of that. He said, just save the time because we'd end up coming back here anyway. I'm just throwing your name on it.
well, but shouldn't, okay, but so if you weren't diligent or your attorney wasn't, then you have to suffer the consequences.
I would still say that's half my house. And I'd be damned if I didn't get half that house.
Well, you're married, so you would have additional rights regardless of whose name it was in. But that's part of the law in Massachusetts as well, right? Married couples have greater rights than non-married couples. Right? You're using the history here, and one could argue the history says they may never get married. That maybe you can't believe. And that goes back to the fiduciary relationship. Can you believe what your boyfriend, girlfriend tells you? Nope.
I know.
No, because that a fiduciary relationship, it's supposed to be a position of trust. Okay, there's some trust, but verify. No? Oh, I'll put your name on the deed. Don't worry. The VA says we can't do it. Don't worry, I'll take care of everything. And he never, despite even assuming he made the promises, he never transfers the property. Does at some point, shouldn't you be suspect of whether your name's going to be on there?
And nowadays, young people are renting together all the time because of the price of rent. It's not like, you know what I mean, it was perhaps years ago where if you were a man and woman living together, you know, it was a little bit more, you could assume that the relationship was a little stronger, I guess.
So her trust meant nothing? Her trust was nothing? She was just, what was she? What was she? She was a leech? Hung on to this guy?
She was-
Her place to live?
She was a roommate.
That paid nothing?
Yeah, apparently.
Paid rent, contributed to what would have been.
Sweet trusting soul that she was.
Well,
I helped her out.
but isn't that what the whole argument against palimony and the rights of non-married spouses are? Is that you can't, you shouldn't just simply trust. You need to have an agreement. You need to have a writing. We're here. We're sort of turning that on the head. There doesn't need to be there's no writing evidencing what they agreed to, what she says they agreed to. None. But she's still getting half the house. And she's getting it on the basis of a constructive trust. There's a fiduciary relationship between the parties. He violated his fiduciary relationship. And this will avoid unjust enrichment to him at the expense of the person to whom he owed the duty.
I think it's just a bad decision because I can see how a constructive trust makes sense if like a beneficiary murders the testator who left them something under the will, and they shouldn't be allowed to profit. But this just really muddies the law a lot, and it's going to put the court right into the middle of people's personal lives.
Well, and that's exactly what it does. And that's where it is a concern, because especially after the fact, people are going to say something that may or may not be accurate of the situation at the time. It says that here the plaintiff was less educated and less experienced. My guess is most of your partners probably are, because they're not in law school. I assume they're not in law school. If they are, maybe I guess you'd be better off. And she relied on him over a long period in important matters. I assume if you're together over a period of time, you tend to rely on each other in important matters. So,
I see Bob.
what?
Actually, no.
What's that mean? Actually, no.
No, not everybody relies.
You're so
He
jaded.
doesn't rely on her.
That's it.
Well,
Not everybody relies on everybody.
no, I hear you, and I agree with. I
Especially
agree.
in our days, a lot of people keep. My best friend's getting married. She has no intention of having her accounts mixed with his. If they're gonna have separate accounts, they have separate legal parties. Not everybody.
I don't disagree with your point on the finances or anything, or actually any of what you were saying with respect to that. I think even in that, even with that, we're going to have separate finances, we're going to do this, we're going to do X, Y, or Z, and you go to, I'll work in Boston, you work in Worcester, or wherever, we get together when we can, whatever the hell it is. But I'm not so sure at this point, she relied on him over a long period of time in important matters. Regardless of the business transaction between you, if you're together over a long period of time, don't you at least get reality checks and bounce ideas off? Hey, I'm thinking of leaving my job, what do you think? Nah, yeah. I mean, isn't that relied on some, or I'm not saying dependent. I don't read that as dependent. It's you rely on someone. You rely on someone's judgment. So wait a minute though. So what I'm setting is a much lower standard than for that reliance that we're talking about. Well, gee, should I quit my job and move with you to Reading? Sure, why not? That's enough to get this ball started here?
Do you think she did it that cavalier? Sure, why not? All right, I'll come along.
I don't know. You know them much better than I from reading the case.
I'm taking it very personally.
Maybe she mentioned, hey, I'll quit my job and I'll do your laundry. Like, all right, you don't know. The problem, and I agree with you that in some cases, maybe a guy kind of duped a young girl and then said, oh, quit your job, take care of my things, and that's horrible. But to make a bright line rule like this is scary because, somebody who just meets a girl and they live together for a while, potentially it worked his whole life. This girl did not, for example. Let's say she had just ruined her whole life.
We talked about women before, right?
I was about to say.
Why does it always have to be the guy whipping the girl?
Just set
What
yourself
did I say now?
up. Maybe the lawyer to sit next to you.
What did I say now?
We call them women now, not girls.
Girls?
Yes.
What's wrong with you? I love people that. I'm like, would you be offended if I called you a girl? He said, no, I'd love it.
How old is she?
What does it matter?
Let me tell you that.
Eventually you could call
Really
somebody under 18 a girl, and the women that I asked were over 18, and they said they would take it as a compliment.
Maybe they should listen to some of the tapes. Double check with them. Okay, anyway, go ahead.
I don't remember what I was saying, but the bright line rule, it's just scary to think that in some cases, yes, it would be horrible that, a girl would think a woman would think she's getting married and give up her career and everything, and that's horrible, and it really is. But she should have made him get married. And on the other hand,
legally, I'll tell you, I don't disagree with the last part of this point. In Massachusetts, we really, before this case, we have some pretty bright line rules on what the rights of married couples are as opposed to non-married couples. That the law provides that type of protection and relief. And we don't provide it for people who live together. And by the way, what period of time would you do it for? A month, a week, a day, 6 months, a year? You're going to decide what that period of time is? You're going to give these additional protections?
Well, this wasn't like, they were together, was it like 11 or 13 years and like engaged for like who knows how long. And wouldn't that be taken into account, like kind of like she was strung along in a way? Because they were planning on getting married, and then they ended up.
So says she.
They were together for so long, so it's kind of.
Where do you get all this 11 years?
well, that would be common law marriage. That's why they.
Parties had a 13 or 14. You're right, 13 or 14 year relationship during 7 of which they lived together. Only 7 they lived together. Right. But okay, it's still a lengthy period of time, is what you're saying.
Right, and like that, and I can't find it right now, but they were engaged to be married also. But they just didn't set the date.
That's right.
So, it could be that she was strung along. And as far as having that reliance on him, if you just never actually married her, then, I guess I could see how that argument would be a little bit more relevant.
I agree with you, but like I said, like you said, they could, they could be, you know what I mean? It's just, the bright line rule like that, I think, is a bit, wrong decision.
But, all I'm saying is I don't think they were just any boyfriend and girlfriend, situation. What? You said what?
Serious relationship.
It was more than a serious relationship, because nowadays, if you're dating somebody for 3.5 months. It's like, oh my gosh, it's so serious. But it's like, they were 13 years. No, seriously, they're like together for 13 years and about to get married, and it seems as though, you know, he's kind of stringing her along, and then just like pull the carpet up from under her. So I guess I could see the argument, but I do agree that, you know, it kind of muddies the waters a bit. But this is a special case, I think.
Ronald Thornton versus Roman Catholic Bishop of Worcester. We've got ecclesiastical courts, and we also have resulting trusts and the like. Let's take a look at, it's page 789, the resulting trust. And what it says, a resulting trust in real estate arises where one party furnishes the consideration to purchase the property, not intending a gift or advancement, yet title is taken in the name of another. A resulting trust must arise, if at all, at the time of the execution of the deed. A resulting trust in real estate arises where one party furnishes the consideration to purchase the property, not intending a gift or advancement, yet title is taken in the name of another. A resulting trust must arise, if at all, at the time of the execution of the deed. At the bottom of that page, 789, it gives you another definition on constructive trust. It says, under mass law, a court will declare a party a constructive trustee of property for the benefit of another if he acquires the property through fraud, mistake, breach of duty, or in other circumstances indicating that he would be unjustly enriched. If he acquired the property through fraud, mistake, breach of duty, or in other circumstances indicating that he would be unjustly enriched, we can seek a constructive trust on the property. Here what they're trying to do is seek a constructive trust on church property, the church itself. I was wondering in this regard about this ecclesiastical courts and suing churches. You know, a few years back our church said, listen, if you guys pledge extra money, we're going to expand the church, we're going to build a new church. So we pledged like $1,000, and they took the money and they didn't build the church. Can we sue them under 93A? Because then they said they needed it for the priest stuff, you know. So 93A, fraudulent deceptive trade practices.
It's tough. They said the First Amendment protects the church in civil matters.
So does that mean I can't go to a civil court? That I have to go to
certain circumstances, but it has to be.
Well, what about this circumstance?
I don't think that's to that law, because they have their own way of dealing with things because of that hierarchy with the Pope, the cardinals, the bishops, and all that other nonsense.
So you're my lawyer. Are you saying I can't go?
I don't think you can.
So what is an ecclesiastical court then? Because that's where I'd have to go, right? If I
handle, within the church.
Within the church, they resolve church disputes. So if I want to sue my church for that $1,000, I've got to go to the church to say, you owe me $1,000, and they'll do right by me.
Absolutely.
Before we're all done.
Write that check for you.
Same as mediation.
So if, and you said, you talked about if it has an organizational structure.
Yeah, levels.
Levels such that you can file your action, take an appeal, and then at the end of the day, Pope will give me a thumbs up or down. That's it? I mean, you can't sue them then if it deals with church matters? Those are ecclesiastical matters and have to be resolved, assuming that that church has some type of internal dispute mechanism that has to be resolved through that process.
Yes.
And civil courts have no subject matter jurisdiction to entertain those suits. Correct?
Yes.
Yeah, that's right, right?
Well, if there was consideration, I mean, then you might be able to sue them under contract law.
But I thought contract law doesn't apply if it's an ecclesiastical matter. Right? I mean, you know, even in the priest cases, one of the arguments they were making is that one of your theories of negligence is the assignment of priests to various parishes, especially after they did bad things, which would create the even sort of knowledge plus the negligence then. And they said, listen, how we assign priests, to what parishes we assign them to, that's an ecclesiastical matter. And top it all off, and you know, we believe in redemption and forgiveness, so that if we reassign them and they promise not to repeat, this is really a church matter and not within the purview of the civil courts. that could be an ecclesiastical matter?
I don't like it, but yeah.
Theoretically, that's their argument, that the First Amendment protects them and precludes this from being able to be resolved by a civil court. It's an argument. It's an argument. I don't think it would likely have been a winner, but the first time you heard it, you said, nah, then you said, it's got some, at least there's a little bit of law that underpins this. Well, how come the court then can look at this Fortin case? Because who owns the church and who gets to use it would seem to be a matter specifically within church doctrine and the like, where the parishioners now want, and we've had more than a few cases after this one, by the way, especially with the recent consolidation of churches, that's the ongoing, I should say, consolidation of churches, Catholic churches in this area. They want specific performance of the alleged oral contract, damages and declaratory relief. They want their church. And the trial court said the bishop was entitled to summary judgment because the court lacked subject matter jurisdiction over some of the parishioners' claims. They lack subject matter jurisdiction because if it's an ecclesiastical matter, they cannot use civil courts. So how does the court actually deal with this? Because at some point they do get to the argument about resulting or constructive trust, but in trying to decide whether they can even entertain subject matter jurisdiction,
They can look at property as long as there's no religious doctrine involved in it.
so if they use what they call over here on page 786, neutral principles of law. Thus, if a dispute can be resolved without inquiry into matters of religious doctrine or polity, a court may examine such sources as statutory provisions governing the holding of property by religious corporations, the constitutions and bylaws of the organization, how do they deal with ownership, and the deeds to the property. If we can look at this in a neutral fashion, then the court may be able to resolve it without having to deal with this First Amendment issue. And that's precisely what they do at the end of the day by dismissing the claims of constructive or resulting trust by saying you really can't meet the requirements here. You're not a resulting trust. You didn't furnish the consideration. And if you did, you were intending a gift or advancement like my 1,000. Yet title is taken in the name of another. You're not going to be able to make a resulting trust. The constructive trust, if he acquired the property through fraud, mistake, breach of duty, and other circumstances indicating they would be unjustly enriched. That's not this situation, but what if the church goes to someone and say, listen, if you give us your 15 acres, we'll build a church and name it after you, St. Mike's. But they really have no intention of building that church. We might have a constructive trust. That's not the situation we're talking about in these cases. The situation in Lowell, is my recollection, came closer to it, where they said, listen, if you guys raise $3 million, we'll keep the church open. They raised the $3 million and they still closed the church. And the people in Lowell sued as well. So we've got a few of these. We've got one down in Brockton.
Were they successful?
Braintree. No, the problem is that more often than not, they're going to give deference to the church's decisions, and they're going to more likely find that it's a church matter. Would claims of...
$3 million.
Say what?
What did they do with the $3 million?
They probably used it to help pay off some of the settlements. I mean, that's at least in part. I mean, there's a lot of money that had to be paid out.
On your other hypothetical, wouldn't you have both constructive and resulting? If I gave you 15 acres of land, you got the legal title, but I'm the one that furnished the consideration.
But I did intend a gift or advancement.
Oh.
That's why I think I'm out on resulting, because I'm giving you the gift, intending it as a gift, but I also am intending you use it for the purpose of what you told me it would be. So I think it's more likely just the constructive trust. You usually, by the way, have an argument for one or the other or both, but you do need to understand the distinction between them. And here, at the end of the day, the court decides that you're not going to be legally entitled to either. You know where another place where we see, and let's see, which one would I say? Well, you tell me which one it is. You see this all the time. Mom or dad is advanced in age. They say, listen, Jonathan, I want to put your name on the bank account so that if I get sick, you need access to pay off the mortgage or take care of whatever the household bills are, you can just go get my money. Jonathan forgets that conversation when Mom or Dad dies and now says, to the exclusion of his 3 brothers and sisters, well, he actually says nothing in most cases until brother and sister say, what happened to Mom's 50 grand? Jonathan says, no, Mama gave me that as a gift. Can brothers or sisters sue? And if so, constructive trust or resulting trust?
It would be
Constructive.
You think it'd be constructive? He acquired the property through fraud, mistake, breach of duty, or in other circumstances indicating he'd be unjustly enriched. You think it'd be both, right? Let's look at the other one as well. A resulting trust in real estate arises, well, in real estate, but it can happen in both. Arises where one party furnishes the consideration, Mom's 50 grand bank account, not intending a gift or advancement, didn't, yet title is taken in the name of another. Title is taken in both names at that point. You could argue that I think it clearly is a constructive trust, and it could be a resulting trust under those circumstances. If a nun wanted to sue on the basis of sexual discrimination, I can do all the crappy jobs in the church, I don't get to say mass, I don't get to do this or that, could they use civil courts?
No, I don't, because that's their bylaws and the Constitution.
It's church matter. It specifically is the right of the church to dictate how things are done.
Yeah, but couldn't they say on the, like, don't they court usually, like, with like Title II, those type of claims or discrimination claims, don't they find those like really important and usually?
They are really important, but so is the First Amendment.
Yeah.
Right? This is the separation of church and state with respect to ecclesiastical matters. Could you go into court to sue for a declaratory judgment in order to obtain an annulment from the Catholic Church? No, right? Again, a church matter. And so there are a number of cases, and we don't really do much with ecclesiastical courts. But there are, every denomination likely has a court of some ability to resolve disputes that would be considered internal church matters. But it's not just for priests and nuns and those that are employed by the institution. It could be those of you that have disputes with that organization that may actually be without a remedy from a subject matter jurisdiction in civil courts. You may have to pursue some relief in a relatively closed system that we know little about and that you're not going to get much access to information. Nessarella versus Peck. Statute of frauds. Again, resulting trust. Plaintiff furnished none of the consideration of the defendant's purchase of the property. You can't have a resulting trust, as this court says, without providing the consideration. What we're looking at here is to avoid unjust enrichment, regardless of how it's going to take shape here. And again, we've got another whole deal with respect to the oral agreement, and it's got some good language about faithless agents and everything else here. And I do think they do. There is some concern about that. A court in equity, I'm at 762, may impose a constructive trust in order to avoid the unjust enrichment of one party at the expense of another, where legal title is obtained by fraud or in violation of the fiduciary duty. But there was no fiduciary duty here between Peck and Nessarella. Nothing suggests there was anything other than an arm's length transaction. And look at this, as interesting as it is after Sullivan versus Rooney. And Peck's family relationship with Nessarella by itself does not make him a fiduciary. So family in and of itself doesn't, but the boyfriend-girlfriend relationship plus more did lead itself to that. And again, they're going to reject the argument that there's a faithless agent here. You can't have a resulting trust because, as it says here, it typically arises when a transfer of property is made to one person and the purchase price is paid by another. the resulting trust then favors the person who paid the consideration, and we can't really satisfy that standard here either. So they find that Peck's claims are groundless, even though factually it would seem that something is amiss, but it's not enough here to have the court go out of their way, as they may have in Sullivan versus Rooney, to try and find a remedy here. There's language within the case that you should understand what it means. It talks about, in the first page of the decision, someone acting as a straw in the real estate transaction. Straw is just a boogeyman. They're not real. They're a nominee only. And that we talk about them as being a straw in the transaction. They use, again, the phrases constructive trust, resulting trust, specific performance. And then there's a phrase here on page 759, and it's just something for you to know, because, believe it or not, I've used it. You use it a fair amount. It's at the bottom of page 759, the last full paragraph. It says, the Superior Court judge ordered the findings of fact and conclusions of law to be entered nunc pro tunc. Nunc pro tunc means then as now. What you do is it's a legal way to backdate the order that you're seeking. Sometimes you need to make sure it was on file as a certain date, but it obviously is not. So you ask that the order be entered nunc pro tunc. And that means then for now, or now for then. I don't know. I should remember my Latin better than that, but I don't. That's it for these cases. I've got to ask you to fill out the evaluation forms for the class. Would someone collect them when they're done? Okay. And then give them to Louise. Thank you. You're welcome. So, section 15 on Thursday, a few more cases, a few more rules, and we're done.
Are we turning in the question?